Hello, everyone, and welcome to Office Hour tonight. I'll take the opportunity this evening to welcome everyone in class, and we're going to cover antitrust law this week, and then next Tuesday will be our last office hour, and we'll cover employment law. And so these two subjects are really the topic for the week 5 exams, so we'll make sure that we cover those and give you some insight to some things. So the first thing we'll get started off with is just the introduction to what antitrust law is, and it's the fundamental objective is to protect and promote free and fair competition in the marketplace for the benefit of the consumers. And antitrust laws, they prohibit conduct that reduces competition by unfair means. And the most developed are criminal and civil penalties. They're among the most severe in the United States, and enforcement efforts are very rigorous. And to further this, antitrust laws prohibit conduct that reduces any competition by unfair means. And antitrust laws are the oldest and probably the most developed of the global competition laws, and the criminal and civil penalties, as we mentioned here, associated with violations of the U.S. antitrust are the most severe. And U.S. enforcement really exercise their jurisdiction as vigorously and as far as they globally can. So it's you know, like I said, it's very very important to our trade. So there's 3 primary federal antitrust laws, and we studied these: the Sherman Act, the Clayton Act, and the FTCA. There's also state and international antitrust laws that are very similar to these federal laws, and violations of any of these laws can lead to severe penalties for individuals and companies. And something that I want to emphasize here is ignorance of the law is no defense. Hi, Marie, welcome.
Thank you so much.
Can you hear okay?
Yes, I can hear you.
I can't hear you. Can you hear me okay?
Yes, I can.
Yes, I can. Oh, there we go.
Thank you.
Oh, I wonder if I was could you hear me when you came on?
Yes.
Yes. Okay, good. That way I don't have to go back and repeat anything. So one of the things that I want to emphasize here is ignorance of the law is no defense. Oops, excuse me, I just have to pull something else up real quick here. And when business conduct is challenged as being anti-competitive against U.S. antitrust laws, courts will apply 2 standards. It's either illegal per se, meaning that it is prohibited regardless of its actual effect on competition. But most conduct is really subject to the rule of reason. It's permitted if it enhances competition. So those are some important things to remember. So really quickly, I'm going to cover these acts. So we've got the Sherman Act, and this was enacted in 1820, and it contains 2 of the most important antitrust laws in the U.S. It addresses conduct that is likely to reduce or limit the ability of competitors to compete, and it prohibits, and this includes price fixing, allocating customer markets, which is really where we get into a lot of problems. And it steps into the territory of monopoly and using that position as an unfair manner. So this is really critical. It's important to note that the violation of the Sherman Act is a felony, and the penalties can be imprisonment up to 10 years and fined up to $160 million per violation. So it's pretty serious. So I'm following
Yeah, pila. Do tomorrow.
Hello, did we have somebody else join us? So just a special note on current antitrust enforcement. It was just announced, well, it's been a while, that it will continue to emphasize prison terms for individuals who participate in price-fixing conspiracies. I would mention the company that I was with went through a Department of Justice allegation for price-fixing, and the actual details of that surrounded salespeople from various from our various competitors in the industry discussing at conferences that they were going to adjust the pricing for fish, and that was enough. They had enough information in emails and phone records to convict them, and so it was a pretty stiff penalty. It was almost $2 million, if I'm not mistaken. Offenders are being sent to prison with increasing frequency and for longer periods of time. And just as a note, in 2007, the U.S. Department of Justice, the DOJ, obtained criminal sentences for 34 individuals, totaling a record 31,391 days of prison time. So corporate fines are also increasing, with over $500 million in fines imposed in each of the last 4 years. So it's something that we have to definitely take note of. Okay, so recognizing red flags. So it's important to learn how to recognize and deal with antitrust in the real world. Antitrust issues typically pop up in these contexts: relationship with competitors, with customers, mergers and acquisitions, monopolistic behavior, discrimination in pricing and promotions, and this can be inadvertent too. But that's why they say ignorance has no place when it comes to penalties and fines in antitrust, and exemptions from antitrust laws. And then there's special industries. So let's talk about relationships with competitors. So price fixing. Section 1 of the Sherman Act prohibits any agreement between competitors that unreasonably restrains competition. Many years ago, in the fuel industry and convenience store owners that had fuel pumps and gas stations would go around and meet and determine what pricing they were going to put out on the street. Well, it was kind of interesting how that was exposed. Some dealers were sitting in at a luncheon in a public place, and a customer overheard it, and that's what started the investigation into some of the alleged price fixing for fuel pumps at gas prices at the gas pumps. So that quickly put a kibosh on that and made it it was already illegal, but it was defined to a much greater degree. So an agreement between competitors to set a price is the most serious type. So that was a good example of that. It includes agreement to set discounts for each charges or payment terms, and it includes bid rigging. It does not have to be formal or written. Remember that. Remember my example of the dealers just sitting in the restaurant discussing this. That was enough to determine it was price fixing. So any questions so far?
No, I don't have any question.
Okay, good. So not only present or future, but past. It just is per se illegal. So we want to make sure that we avoid it. Oops, sorry about that. I'm giving you probably a headache. There we go. Relationships with competitors. So an agreement to allocate customers, territories, or business opportunities is always illegal, meaning I'll take these customers over here, you can have these. You can't do that. Competitors cannot agree that one will not sell in certain areas to certain customers. And they can't agree that one will not bid on a certain contract or not compete for customers. Boycotts, agreements not to do business with a supplier or customer, is an illegal boycott. So there's a lot of rules around price fixing and relationships. So these red flags are great little tips. Oops, where's my, I'm using a different type of a, I guess I shouldn't put it in PDF. That doesn't help, does it? So relationships with customers. Antitrust laws prohibit certain agreements between companies at different levels of distribution chain, and commercial decisions must be unilateral. Again, there can't be discussions or agreements with a customer, competitor, or supplier. We can decide which customers and suppliers we want to deal with as long as we make those decisions independently. We can't strategize with somebody else. So that's really the key to that right there. So I would always, if you have a legal department, you know, I would always remember to touch base with them. Okay, so a little pop quiz. So a pricing agreement between a supplier and a customer is always what? Is A, true or false? What do you think? Probably B. All right, where'd it go? Boy, this is sensitive. So would you agree that it's B?
Between the customer and the supplier, I think it could be either way. But between the suppliers, we already said that is illegal.
So a pricing agreement between a supplier and a customer is always per se illegal. So it's conduct. Price fixing between two or more competitors is considered illegal. So if you've got a supplier and a customer, so the statement is false. Okay, so some conduct, price fixing between two or more competitors, for example, is considered illegal, meaning that it violates antitrust laws. Even if it benefits consumers and does no provable harm to competition. But B, the answer is B, it's false. It's not always illegal. And because you can have some agreements between a supplier and a customer, but as long as it's not a price fixing, which is considered illegal, but a pricing agreement is not necessarily illegal. So we just need to watch out for that one.
I see.
So relationships with customers, red flag number 5. So this relates back to the pop quiz. A resale price maintenance agreement between supplier and customer sets prices at which the customers will resell suppliers' products or services. So this can happen, okay? If it's assessed under rule of reason. For instance, at a distribution company that I worked at, when we had a promotion, on certain products, there were rules that you couldn't sell the product for less than a certain price because we wanted to stay competitive in the market. And so it couldn't, the price related restrictions, if we are going to assess it under a rule of reason, it has to provide a reasonable pro-competitive justification for price restriction. Does that make sense? That one you have to be really careful. Yeah. Oh my gosh, this is so sensitive. Same thing with geographic or customer restrictions. So that one's pretty self-explanatory. Exclusive dealing, again, excuse me, geographic or customer restrictions, tying. You can't tie certain things in, you know, and that's been, again, that is going to be based on the rule of reason for tying, because you can have tying promotions. Excuse me. And we see those out there. But on the tying on number 8, the red flag one, to offer to sell a customer a desirable product only if the customer agrees to buy a less desirable product, are usually unlawful. There are certain circumstances where you can do it. Red flag number 9. You've got reciprocal dealing. This means agreeing to buy the products or services of a supplier on the condition that the supplier also agrees to buy products and services. It's kind of like a quid pro quo. And that is illegal. So you want to avoid any appearance of an agreement that links your purchases from the supplier to their purchases from you. It's kind of like I scratch your back, you scratch my back.
Yeah.
Doesn't work out there. And then dual distribution. Everybody has to be treated fairly, and so you have to just really be careful with that. So in M&A, mergers and acquisitions, the Clayton Act prohibits M&As that could substantially lessen competition or create a monopoly. The most recent one that I was a part of was Bumblebee Tuna tried to purchase Chicken of the Sea, and during the middle of that acquisition, the Department of Justice got wind of some price fixing, and that's where my company came into play, because my company also sells tuna. And so the Department of Justice shut that down. It was in antitrust law evaluation, and that's exactly what that's for. When a company is in the process of being purchased, going public, it goes through antitrust law, and that's what it's trying to do. The antitrust committee, they're trying to determine whether or not there's basically any funny business. So it's to ensure that fair trade is in the market. And so when you go through an M&A, you do have a lot of reporting that you have to expose to the government agencies that evaluate the transaction. So companies considering a merger are allowed to share information with each other so they can accurately evaluate their prospective business opportunity. True or false? So true is incorrect. B is correct. You have to follow the rules of merger and acquisition, and there are rules prohibiting the sharing of sensitive business information by competitors. And those rules must be followed, and they're very specific. So quickly, we'll just zip through monopolistic behavior. Sherman Acts. So the different acts, I don't know if you followed that in your learning, but it prohibits, we have the different acts prohibit different things, and the Sherman Act prohibits monopolization. And basically, this is just unreasonable business behavior that's designed to achieve or maintain a monopoly power. In other words, the ability to control prices, and that's why monopolies are illegal. They control prices and they drive competitors out of the market. The usual indicator of monopoly power is market share over 60%. And so once you reach that, then there's going to be some penalties, and some decentralization is going to occur. It requires deliberateness, conduct or behavior that shows monopolistic intent, such as predatory conduct, tie-in sales requirements, output and supply contracts, foreclosing on small competitors from the market by controlling sources of supply and distribution. That's happened before. Okay. Whoops. So this was a Supreme Court case that clarified predatory pricing and bidding on claims and bidding claims. And this is an Oregon sawmill, and it accused a competitor of engaging in predatory pricing, violating the Sherman Act. And they were doing this by bidding up the price of saw logs to prevent the plaintiff from being profitable. And in the ruling, the U.S. Supreme Court held that the test should be the same for predatory pricing and predatory billing claims. In other words, the plaintiff must show that the defendant had considerable market power and wielded it to drive its competitors out of the market. And the court, this is the U.S. Supreme Court, mind you, they reversed an $80 million jury verdict for the plaintiff, finding that there might have been legitimate reasons for the defendant's bids, such as increased consumer demand and a hedge against future price increases. So this was an interesting case, you know, that went against the plaintiff, the Oregon sawmill. So the courts look at this with very serious intent. And even though it may look predatory, you know, you got to get down to the really root. And in this one, they saw that he had legitimate reasons for the bids. And so again, here we talk about predatory pricing. Refusals to deal is a very typical behavior of a company trying to drive themselves into a monopoly and a monopolistic position. I'm going through this pretty quick, so if you have any questions, fire away.
Okay.
Price discrimination, same thing here. Robinson-Patman Act prohibits a seller from discriminating between customers on price. You can charge different prices, you know, if you've got reason to it. In other words, if you've got a large quantity buyer over here of certain products and it puts you into a different tier pricing, that's legal. But it just can't lessen the competition. And so typically, for instance, a grocery store, that's a pretty good example where you have the large grocery stores competing against like a small convenience store. Large grocery stores usually have different types of pricing because of the quantities that they purchase. And that's why you'll see higher prices at the very small convenience stores, because they don't get that kind of pricing. But you've got two different forms of competition. That's why that's allowed. Let's see, what else? Oh, okay. So here comes another pop quiz. Which of the following is not a type of price discrimination addressed by U.S. antitrust laws? So we've got A, B, or C. A supplier sells widgets to stores owned by 20 people who are over 40 for $100 each, but charges $200 to stores owned by people under 40. A supplier sells widgets to big box chain stores at $100 each, but charges $200 to small independent stores. A supplier sells widgets to all its customers at $150 each, but includes promotional materials free of charge for orders by its largest companies. So, which of the following is not a type of price discrimination?
I would say C.
Let's see. Prohibits. So it's A, okay? The Robinson-Patman Act prohibits a supplier from discriminating between competing customers regarding price, terms, or promotional service. It does not cover discrimination on the basis of age.
Oh.
So it's not, it won't touch this. It kind of gives you a red herring because you've got $100 each and then $200 each over here. So if somebody were to file a claim, you know, you could have B and C in there, but they won't touch A because it's based on age discrimination. And that's not a type of, it's not a pricing, that's not a type of price discrimination addressed by U.S. antitrust laws. B and C, yes, if they're discriminatory. It was kind of a trick question. It wasn't very fair. Okay, meeting competition. So these are the types of defenses. Permits a seller to charge lower price to a buyer if done in good faith. And I'm going to post this so you'll be able to kind of go through it and read through them. I'm going through them pretty quickly. And I don't really want to cover them all because not everything is on the quiz that you really need to know about. Really, the acts are what you want to understand and what price fixing might take a look at. Promotional services, insurance is exempt from antitrust law. Healthcare is exempt from antitrust law. They have their own set of rules, and they have these are regulated industries, and a lot of them have state zones that they fall under. So really, you don't need to worry about that as far as the exam goes, but you need to have an understanding of what the different types of businesses are subject to as far as regulation and conduct. Final quiz. Okay. Oh, I know what it was. Oh, shoot, it didn't come up. Doggone it. Oh, wow, there was supposed to be a click here, but it didn't work. Oh, doggone. Oh, shoot. Well, sorry about that, Marie. I had 3 questions here, and they're not, my link popped. I guess it fell off or something. Doggone it. Oh, well. Well, what questions can I answer for you tonight? I appreciate you joining me. Thank you.
I don't have any question really. I just want to participate and see if I can understand a little bit. Even I try to understand, I read and stuff, but when I get to the exam, a little bit confusing.
I know. And it takes a lot of time. You guys are covering topics that I took 2 years to cover.
Pretty vast.
Yeah, we're covering a ton of territory. It's probably been one of my biggest challenges with this class. I remember I took a business law class prior to going to law school, and I mean, I was like, my head was swimming, and it covers a lot. I'll tell you what are great for you to understand are the cases. The more that you can understand the cases, the more you'll get to understand how the courts look at law. And if you ever want to compare something, just go try to Google a case that, you know, is similar to what, you know, you're trying to grasp. Some of the cases can be very confusing. Biker versus Mans, that was a terribly confusing. I've never cared for that case. My head still spins when I read that case, and you know how they. I mean, I understand the ruling and the rationale, but how they applied it to that case was a little bit of a challenge, if you ask me. But I will say that reading case law will really help.
Okay.
Yeah. And good job with your group. You guys have a good group.
Thank you.
Yeah. You guys do some really great work, and the you know, the review quizzes that you put together are really well done. So thank you. You're doing a great job.
Thank you so much.
Well, we'll go ahead and close off tonight. And if you have any questions, don't hesitate to shoot me an email. Did you finally get your case brief posted for week 11?
For this week?
Yeah. Did you have a problem? The link was broken, but they got it fixed today.
I know. I tried. I'm gonna try it again tonight.
Okay, good. Well, let me know if you have a problem. Okay.
I will do that. Thank you so much.
Okay. Thank you. Bye.
Bye.